the point, don't you, in your book, that a specialist, an Indigenous specialist, Dr. Ingram, questions whether of the 800,000 odd Indigenous people, she is suspicious that perhaps up to 300,000 may not be really Indigenous, does she not?
She does indeed, and she's not the only one who was concerned about this. And that's a huge proportion of the population that you know, and that is only going to get bigger if people can just put their hand up and say, yes, I'm Aboriginal, or even discover that they have some Aboriginality in their past some generations ago. And many of the people that are in this boat have only come to their Aboriginality later in life, and they've not lived that life. So to me it's ridiculous that we should have this such a powerful provision. In fact, what this referendum will do will establish an Aboriginal polity as a third constitutional entity, if you like, alongside the Commonwealth and the states. And that's a very powerful position to be in. So we cannot leave it open to the vagaries of Parliament or even the High Court to decide who may or may not be on the voice.
I think you're absolutely right. There are so many occasions now when you have contact with government in various ways, and you have to fill out a form, and quite often you have to do that on your computer, and you come to a point where they ask you whether or not you are Indigenous, and it's a matter of just ticking a box. And I suspect that when people realise that there may well be an advantage in that dealing with the Commonwealth or the state, there may be an advantage in ticking the box that way. Many people are ticking the box that way. And here we have an Indigenous expert expressing exactly the same position, that there is no precision in relation to the definition of who is not Indigenous. But there's an argument made all along, and you've no doubt heard it, that if the government can make laws, if the Parliament can make laws in relation to the Indigenous people, special laws in relation to them, surely it's fair, is it not, that they be consulted before those laws are made. Isn't that reasonable?
Yes, well, it is. In essence, it is. If the government were to make laws that uniquely and specifically affect Aboriginal people, that is, laws made under Section 51(26) of the Constitution, the government can make laws in respect of Aboriginal people. And if that's the case, then certainly Aboriginal people should have a say in those laws. Now, I've done a bit of a rough audit, and since the 1967 referendum, I've identified 65 pieces of legislation that presumably were enacted under Section 51(26). Of those 65, only 5 of them could be considered what I would call coercive. In other words, legislation that might be seen as discriminatory against Aboriginal people, and they all related to the 2007 Northern Territory intervention. All the other pieces of legislation did deal with native title, they deal with grants, they deal with heritage protection, they deal with educational allowance supplement, and they are all beneficial to Aboriginal people, and I've got no doubt that they are in the canon of our law because Aboriginal people lobbied for them and asked for them and wanted them, so they had a say in the making of those laws. And of course, we're now talking about going beyond that. The remit of this voice is well beyond laws that are made under Section 51(26). It's any law that affects Aboriginal people. That's any law that affects you or I. And they already have a say through their 11 parliamentary representatives in the federal parliament alone, plus the National Indigenous Australians Agency, which is effectively the Department of Aboriginal Affairs, a salary budget of $1.5 billion per annum, and land councils, the Council of Peaks,